Thank you, ESA São Paulo, for having us today here. We have the pleasure of listening to Stefan Kröll. Professor Kröll, would you please introduce yourself? I mean, most people watching here, they know, but they don't know your background. Would you mind tell us a bit about your background?
I'm Professor for International Dispute Resolution at Bucerius Law School in Hamburg, Germany. Bucerius is a private university, the only one in Germany, the top law school in Germany, and I'm teaching there 50% of my time. The other 50% I'm either working as an arbitrator in arbitration proceedings, or, and that is one of my pet topics, I'm one of the directors of the Willem Swiss Arbitration Mood, which is an international student competition where we have a lot of Brazilian universities participating. And in addition to that, I'm presently the chairman of the German Arbitration Institute.
I see. So if you work currently at the German Arbitration Institute, I figure you handle, I mean, your institution handles a number of disputes. And we're basically talking about international commerce here. And with international commerce, with any kind of commerce, we have dispute. But what should be exactly what an attorney should be looking for when we're handling international disputes? Is there any specific characteristic that differs from domestic disputes in international commerce?
There are. And the role of the attorney is much more important in international disputes than it is in national disputes. The reason for that is that you have, as an attorney in international disputes, much more flexibility to find a good solution for your client by playing the different roles. The issue is that in international dispute, very often the first question which arises is which law governs. And if the parties have not in their contract agreed on that, you can make different arguments, and very often the outcome of the case is determined by the applicable law. I can tell you from my own experience, one of the first cases I ever had as a lawyer was a case where one of the parties was pleading German law, and he was a Turkish employer pleading German law because he had a Turkish sole agent. We looked at the case and then realized it would be much better for him to plead Turkish law, because under Turkish law, the claims of the sole agent in Turkey were much smaller. And the Turkish sole agent had a Turkish lawyer who was very happy that in the end we also pleaded Turkish law, not realizing that by choosing the wrong law in that case, basically he lost 50% of his claim. Because under German law, when you terminate a contract with a sole agent, the compensation for that is much higher than under Turkish law.
That's very interesting. So from what you said, I just gathered that the contract itself did not determine a specific law. Is it common to have gaps such as not having the applicable law in a contract?
It really depends on what type of parties you have. The sophisticated parties, you don't see any contract, international contract, without a choice of law clause. So everyone knows how important it is, so they agree at the beginning which law should govern the contract, also to understand what are my obligations and what are my rights. How do I have to behave if goods are delivered to me? Do I have to investigate, examine them within a very short period of time, or can I take my time? But very often you have small and medium-sized companies. They have been operating nationally for quite some time, but then there is the first foreign customer. And what they do, they very often take their domestic contract, translate it into English, and have the impression that is the contract which serves very well my international transaction as well, without realizing that there's an entirely different dimension of applicable law. Is it my law, or is it the law of my opponent which may be located in a different jurisdiction. In Europe, it may be even more prevalent. Here in Brazil, you fly 4 hours and you're still within Brazil. In Europe, if you fly 4 hours, you have basically covered the entire of Europe. And these are 27 states, all of which have a separate judicial system, have a separate contract law. And one of the big tasks of the European Union is try to harmonize slowly the various laws to reduce also transaction costs. Because as a party, if I have to deal with one contract under Belgian law, one contract under French law, one contract under German law, in principle I need 3 lawyers. I have to train my people 3 times to what issues they pay attention.
That's excellent. So if we're talking about international commerce, and you were bringing the example of the European Union, my next question would be, is there any international treaty that encompass both the European Union and other countries regulating the applicable law to the merits of international sale, a transaction for sales of goods?
There actually is, yeah. So already in the beginning of the 1920s, people realized that the differences in the law is an obstacle to international contracts. And there was a movement to harmonize the most relevant contracts internationally. And the most relevant contract internationally is the sales contract. So they started works on harmonizing the sales law, resulting first in a convention which was driven primarily by European countries. And then when UNCITRAL, the United Nations Commission for International Trade Law, was founded in 1968, they took up the work and said, we try to have an international convention which is acceptable to everybody. And that's how the CSG, the Convention for Contracts for the International of Goods, basically was signed in 1980. It entered into force in 1987, and now we have countries all over the world which are contracting state to that convention, which, if applied, would probably cover more than 80% of the worldwide trade in international goods.
It's very good. Just for the record, Brazil since 2005 is also a signatory of the CISG. One question very important for attorneys. As long as Brazil, such as I understand nearly 95% of international trade is covered by signatories of this treaty. So basically any relevant country in international commerce terms is a signatory, or if it's not a signatory, they use this law. So we have a sort of a uniform law. But for instance, in Brazil, we have our civil code, and we also have the CISG. How can one attorney mostly understand which is applicable in a contract? Is this a opt-in or opt-out? How does that work?
That is one of the difficult questions, and that's one of the questions why very often the CSG is not properly applied, because people do not realize that it is applicable to them. So the CSG is the Brazilian law for international transactions. It's part of Brazilian law, and whenever a transaction qualifies as an international sales transaction, it is covered by the CSG. If the parties, for example, agree in a contract, we want Brazilian law to be applicable, and it's an international sales transaction, it is the CSG which is applicable. And that is something which for some time created considerable problems, that students learn the non-harmonized local law, German sales law, Brazilian sales law, but at university they do not learn the CSG. And they don't realize that in their transactions the CSG would be applicable. You will find the requirements for the application of the CSG in its articles 1 to 6. And it requires first an international contract, it must be a sales contract, and then the issues must be covered by the CSG. because the CSG is not, for example, regulating the validity of the contract. It regulates the formation of the contract, and it regulates rights and obligations of the parties. And last but not least, the CSG is based on party autonomy. That means the parties may either exclude the CSG entirely, or they may provide their own rules, for example, for the place of performance. And then these own rules overlap or basically derogate the relevant provision of the CSG. The CSG is just a fallback provision. If you have not agreed on anything, then the CSG provides the solution.
So bottom line, in case of silence, if you have no provision at all, the entirety of the CISG is applicable in any contract drafted by a Brazilian attorney.
In any sales contract, which is an international sales contract in the sense of the CSG. Sales contract means not only sale of prefabricated goods, but also some of the mixed contracts, where you, for example, ask me to produce something for you and then sell it to you. And there is a provision which says if the preponderant part is still the sales part, then it's a sales contract. And as I said, it must be an international contract. An international contract requires that the two parties, the seller and the buyer, have their places of business in different contracting states. It does not require that the goods are actually shipped over the border. So even if you have a Brazilian company which enters into a contract with a German company, and the German company has a Brazilian subsidiary and it delivers from the Brazilian subsidiary, it may be an international contract because the two contracting parties have their place of business in different contracting states. And then there's a second provision. If I do not have my place of business in a contracting state, but the choice of law provisions lead to the application of a law of a contracting state, meaning lead to the law of Brazil, for example, application of the law of Brazil. Even in these cases, the CSG is applicable because, as I said at the beginning, the CSG is part of Brazilian law. It is that part which regulates international sales transactions.
Excellent. Another question that I have that many people would have is, we're talking about a body of law drafted by international scholars on the subject of sales, but we have so many domestic tribunals, not only arbitration, but also state courts dealing with this. Do you believe we have some sort of uniformity in the application of the CISG?
That's, again, one of the problems in the application of the CSG, that very often the judges naturally come with their own system in mind. And there are a number of concepts in the CSG which are fairly broad, because it has to be applied to millions of different transactions. So, for example, you have to give notice of defects within a reasonable time. What is reasonable naturally depends on where you're based, what your local law says. In Germany, we have to give notice of defects within a very short period of time, which means German judges, whenever they interpret reasonable under the CSG, they have in mind what the German law requires them to do. So they start off with a very short period of time. By contrast, the French judges, they don't have any concept of you have to give notice within a reasonable period of time about defects, not to lose your remedies for the defects. For them, reasonable period of time would be very long. So how do we deal with that? To avoid that in the end we have the same text, but entirely different applications in different jurisdictions. The drafters of the CSG had that problem in mind. So they included a special provision on interpreting the CSG, which is Article 7. And Article 7 contains special rules for interpretation of this convention. You have to interpret it with the international background in mind, trying to harmonize its application, as well as keeping in mind good faith. What does that mean? That means if I have to look at the international background and try to apply the CSG in a harmonized way, a judge in Brazil also has to look at the law, at decision of other states. So I could easily plead in a Brazilian court, present them with a German decision and say, this dispute, this problem has been decided by the German Supreme Court, and the German Supreme Court said that a reasonable period of time is 4 weeks. There's naturally no precedent. It's not binding upon the Brazilian judge. But the Brazilian judge at least has to look at it and say, okay, this is how they interpret it internationally, in Germany, in Switzerland, in wherever, Russia or any other country. And I want to deviate from that now, so I have to at least give reasons why I deviate from that, why my case is different, why I may have to distinguish my case from the German case. So Article 7, the international harmonized interpretation, the autonomous interpretation of the Convention is one of the hallmarks of the Convention. How does that work? There are databases where academics and people interested in the CISG select the leading decisions from all over the world. And very often the students which participate in this competition I mentioned, the Wilhelm-Swiss arbitration mode, they are enthusiastic about the CISG and they provide these databases with the decisions from their jurisdiction. The probably best known database is CISG Online, which is run by Professor Ulrich Schröter at the University of Basel. They have more than 6,000 cases, most of them with translation, dealing with the CISG. It's available for free. You have a problem with Article 39 of the CISG, you just go to the database, type in 39, and then it will tell you all the cases, international cases on 39, which may be relevant for you.
By the way, we have that in Portuguese as well. I mean, we have the CISG database. You just Google it, you will find.
Yeah.
Brazilian Code of Obligations in our civil code is heavily based on the German Code of Civil Obligations. One question that we get quite often is, of course, there are, just like you said, different deadlines, different concepts, very broad language for preponderance, for instance. Do you think that the rights of obligations of the CISG differs greatly from German law, which will probably be the same in Brazil?
I'm not sure on which part of the German law the Brazilian code is based, because Germany changed its sales law 10 years ago to make it more in line with the CISG. So some of the old concepts coming from the Roman law have been abandoned in favor of concepts which underlie the CISG. So the German present sales law is very much like the CISG. There are a number of differences, but we have weeded out some of the major differences which existed before, because the CISG, when it was drafted, it was a compromise between the various legal families, the German, the French, the common law system, the Chinese system, where the drafters, which were all experts in international trade, tried to look at the most reasonable solution for international trade. And that is one of the interesting part of the CISG. The Brazilian law, the German law, the non-harmonized law, they are drafted primarily for domestic transactions. The CISG, by contrast, was drafted from the beginning for international transactions. So that means certain particularities of the international trade are much better reflected in the CISG than they are reflected in, for example, the German law. I cannot talk about the Brazilian law because my Portuguese is non-existent and I cannot read the Brazilian civil code, so I have no understanding really what the Brazilian civil code says.
We're discussing not only amendments to the civil code, but also the enactment of a new civil code. But coming to it, exactly what you were saying, things like one of the issues of the CISG I like the most is the duty to mitigate losses, which we didn't have in Brazil, but pretty much like happened in Germany, Brazilian law has evolved. And also, like you said, I mean, Brazil is a continental country. It's probably a lot more troublesome to sell from Porto Alegre, which is in the deep south, to Natal, which is in the deep north, than in Europe, or maybe as far off as the United States. So some of those ideas, they do make sense in Brazil. And just like I said, mitigate losses. That was something that we didn't have in Brazil. What do you have to say about mitigation, the duty of mitigation under the CISG?
Let me go a step back. One of the issues of the CISG was always we tried to find a solution which makes economically overall as much sense as possible. And one of the big differences between the old German law and the CISG was that under the old German law, if there was a breach of contract, you could avoid the contract, even if the goods had already been delivered. So the CISG said, if I have shipped the goods, for example, to India, and then I have to avoid the contracts, and I have to take the goods back, I have to ship them back to Germany. That's a waste of money. The German seller probably is not in the position to sell them, resell the goods in India because he doesn't know the market. So the CISG says, what we do is we order in principle the buyer to keep the goods. The buyer should resell the goods on its own market if he doesn't want to use them, and then claim damages. So already the remedy of damages, instead of avoidance of the contract and shipping back the goods, was a kind of mitigation of losses. And in addition to that, the CISG has this broad mitigation duty. You have a claim for damages, but nevertheless you should do your best to mitigate these damages. To look around for potential buyers of goods which you may not want to use because you're a premium seller, and someone else may be willing to use the shirts with certain defects because they are a B product seller. And then it's for you to look around and sell that to that party in the market. You're in a much better position here in Brazil to sell goods which may be produced in Germany if they are once there in Brazil, to sell them on the Brazilian market and thereby to mitigate a little bit the losses which are there. As you rightly said, it's a very broad obligation. What mitigation means really depends on the particular situation. And that's one of the areas where it may make sense to look to the international cases as well, where people have, or courts in certain jurisdictions have decided, okay, for mitigation steps, you have to take the following steps. And the other thing is beyond what can be required from you. I'll give you an example. If I'm a premium seller, or if I'm a seller of premium goods, and have a certain reputation in the market, and I just have a market overview over that very narrow market, you cannot require me to make a market research, what is the lower market whatsoever. Yeah? I'm only required to take reasonable steps which are not disrupting my business too much to mitigate the losses. It's not that the German party then can say you sold them at a lower price than I expected because you didn't really make any investigations. There is no such expectation. However, if you have an overview of the Brazilian market, I would expect you to sell the goods to the other party where you get the highest amount.
Excellent. Let's change, still in the same subject of international commerce, but change it a little bit. What's the preferred system of dispute resolution nowadays? Imagine we have a buyer and a seller, a Brazilian buyer and a German seller drafting a contract. And just like you mentioned yesterday, with international commerce comes international problems, and problems arising. What are the avenues open for a businessman?
What are the avenues open for businessmen? When you look at the option provided to you by the state, is either you negotiate a solution. If you cannot negotiate, the state offers you state courts. And in international transaction, you have the state courts of the buyer, you have the state courts of the seller. The buyer is probably unhappy if he has to travel to Germany, and the seller is unhappy if he has to travel to Brazil to resolve the disputes. Therefore, in international transaction, those parties which are dispute-wise, which have a lot of dispute, for whom dispute resolution is something which is normal, they all go to arbitration. There's very little.
I'm really sorry to interrupt you, because you just mentioned probably a Brazilian, and that's going back to my example. You're a German, I'm a Brazilian, and you said probably a Brazilian wouldn't want to go to the German judiciary. In my mind, the German judiciary doesn't have the problem. Brazilian judiciary is good, but people don't like using Brazilian judiciary because it's overloaded with cases. It's an archaic system. It is a problem. But I don't see that problem in Germany, for instance. Why wouldn't a Brazilian want to go to Germany?
First of all, German courts are good. Yeah, and they are reasonably fast. But that has also changed a little bit over the years. Contracts, disputes have become much more complex. You have other areas, you have artificial intelligence and all that. And as a judge, the idea is as a judge, you should understand everything. Yeah, we have not the system of very specialized judges. These are judges for technology, these are judges for banking. There are certain areas where we have specialized judges. Construction, banking, IP, but that's it. That is just an issue where you said, I'm left with a judge which is predetermined on the basis of certain criteria, which have nothing to do with the case. They have to do, for example, with the starting of your file, of your name. Yeah, so this is the judge which is responsible for all disputes involving someone whose name starts with an F. In arbitration, you can always select your judge. But the part where it becomes really why a lot of Brazilians don't want to go to Germany, despite the quality of the German courts, is they have to plead in front of a German judge. The German judge has been brought up in Germany, has lived in Germany, has been trained in Germany, and understands very well how Germans behave. But he may not understand as well how Brazilians behave. So the expectations from a German judge to a Brazilian are the expectation the German judge would have on Germans. And for that reason alone, you always have a slightly disadvantage with that, because you're not living in the system. I know a lot of Brazilians who are much more German than the Germans. They would have no problems there. But Brazilians which are not very German, they may have problems understanding the judge, or the judge may have problems understanding the situation in Brazil. And again, I'm spending all my professional work in international transactions. And I think I'm aware of these differences. But I can tell you from my own cases that I sometimes forget that, approach cases with a German mindset and only realize at a certain point in time, oh, the situation is entirely different. When I, for example, have to evaluate the damage of a particular dispute, my point of reference is always what would be the damages in Germany. If I, for example, have to clean up certain environmental damages, what would it cost in Germany? In other jurisdictions, it may be much cheaper because labor is cheaper, it's easier to get permissions, whatsoever. Yeah? But you're always trained and you're always somehow culturally biased towards your own system. And that's one of the reasons why a Brazilian probably may be hesitant to go to the German courts with a German. You may select the English courts saying, okay, there's no advantage for the German because the English judge is trained in England, has an English mindset, not a German, not a Brazilian one. But when you do that, why not go the entire step and say, I want to select my judge? And that's what I said, what all the dispute-wise companies do, which have a lot of international dispute, they go to arbitration.
And what are the main differences between arbitration and state court litigation?
What are the main differences? You have first much more party autonomy. Arbitration is entirely a creature of party autonomy. That starts with the choice to go to arbitration. You cannot have any arbitration, or in principle you cannot have any arbitration without agreeing to it. The fallback mechanism is always the state courts. Arbitration requires an agreement of the parties to go to arbitration. But once the parties have agreed that, you are largely free first in selecting the arbitrators. So you select someone which has experience in international sales transactions. Perhaps you select someone who speaks German and Portuguese, that you don't need a translation there. He or she can read all documents in both languages. They can understand witnesses in both languages. You can select someone who is available on a short notice, who has perhaps dealt with comparable cases, has other experiences which may be useful for you. Then you can organize the procedure the way you want. There are certain limits. It must be fair. The parties must be treated equal. But within that broad scope, you can agree on the procedure. Service. Very often courts have to serve via the official channel, meaning you have to go through the ministry and then serve via the ministry in the foreign country. In arbitration, private mechanism, you serve via DHL, UPS or whatever, much faster. If you have a dispute between a German and a Brazilian and the goods which are allegedly defective are in Brazil, it's very difficult for the German judge to get the permission to fly to Brazil to have a look at the goods. In arbitration, you just fly over. And so there are a number of areas where being able to create your own procedure is very helpful. You can, for example, say, I want to have the first hearing in Germany and the second hearing in Brazil, that each of the parties has to travel once. All these wouldn't exist in the state court, it exists in arbitration. And last but not least, and that is very important, that is, at least from the dispute wise company, according to them, the main advantage of arbitration awards are more easily enforceable worldwide. There is a convention, the New York Convention, which has 172 member states. That means everybody in principle has signed it. And everybody who has signed the New York Convention is obliged to recognize and enforce arbitral awards coming from a different contracting state.
So you could enforce it anywhere, now, assuming in our fictitious case, from what you're saying, if you win this arbitration and you have an award, you could enforce, for instance, in New York. Is it correct?
Easily enforce it in New York. The New York courts would be obliged to recognize and enforce that award as if it were a judgment of a New York court. And you could also enforce it in India. You could enforce it in China. They have all signed the New York Convention. I'm not sure how many treaties Brazil has signed with other countries to enforce Brazilian decisions. Whether it would be easy to enforce a Brazilian decision in China.
We have none, just for the record. We have something in Mercosur, but no bilateral treaty. This is indeed a big advantage. But I see that our time is almost off, but we have 5 minutes. And you were mentioning the last time we talked about a different trend in dispute resolution. In addition to state court and arbitration, are there any other cost advantageous means for dispute resolutions available to international commerce?
There are many. As I said, dispute resolution is all about party autonomy. And you can create your own mechanism. The most well-known ones are mediation, conciliation, which are consent-oriented dispute resolution mechanisms, where you have a third party trying to help the parties negotiating a settlement. And when they negotiate a settlement, one of the good things is that the parties do not have to spend as much money on the lawyers. they have a solution which has been made by themselves, where they're standing much more behind the solution, and which can also go beyond the normal dispute. Meaning that in a dispute, it's very often a distribution of gains and losses. In mediation, you can think about the next contract. It's not only our dispute about this contract may be resolved by me giving you special preferential treatment for the next contract, and thereby creating new business. Conciliation is also a third party helping you and then perhaps telling you that would be my decision. You're not bound by that. You can decide whether you want to accept it or not. There's also expert determination, where you have a third party giving a first binding decision, but it is not a judgment. It's more like a contract. Yeah? You still have to, if you want to enforce that decision, you still have to go through a state court procedure, but there is very little defense against the decision then of the expert. As I said, there is a myriad of mechanisms, and you can, as a good lawyer, create the mechanism which is the most suitable. There's a very interesting one which is called baseball arbitration. And baseball arbitration takes into account that very often when you go into negotiation, you come up with a very high figure which is still supportable, which is above what you would normally expect to get. To be able, within the negotiation, to lower it, and in the end to reach a result by compromise, which is what you really wanted. Baseball arbitration tries to avoid these overloading of requests by saying, okay, there is a third party, and the third party gets two options. The buyer brings one option, and the seller brings one option. And then the adjudicator, the arbitrator, can only select one of the two options, the one which he or she considers to be more reasonable. That has already at the beginning the effect that the big gap, where one says a particular low price and the other one a particular big price, narrows considerably, because you're not coming with this outrageous request, because then the risk that he definitely takes the other one. Yeah? So you come with something which is much more closer to reality, or perhaps even a little bit below what you would normally expect to get the dispute solved. And one of the big advantages of that is also you can solve the dispute in a much faster way. Because one thing we as lawyers often tend to forget, disputes are a fact of life. Nevertheless, they strain the business relationship. Whenever you have a dispute, you have to have someone taking care of the dispute. And as a company, as a business person, you always look this direction. You look forward. Dispute resolution is looking backward. What happened in the past? And that's already a considerable disruption in a company. You have to get the people, which may have left the company, to tell you what happened 3 or 4 years ago. And all of that may be avoided if you go to mediation. My experience is that, and which surprises me, that people do not see the value or the benefits of mediation sufficiently in international transactions. It's very often still, if I have a strong case, I will try to litigate it. For me, it's always, if I have a strong case, I nevertheless have a look at it and see whether there are any other non-legal factors, economic factors, which nevertheless make it useful for me to go to mediation. And in a mediation, I will only accept the final result if it's favorable to me. Favorable means either financially now or financially in the future, or if I have, for whatever reasons, which are maybe not related to this particular contract, but are related to other contracts, my reputation in the business are favorable to me. These are factors which are non-legal factors, business factors, which you can take much better into account in a mediation than in an arbitration or even in court litigation. Arbitration and court litigation, they are based on an application of the law. Mediation is negotiating with a business mindset in the shadow of the law.
Excellent. Let me ask you one last question. And we're basically floating in very subtle issues relating to a contract. And you mentioned, I mean, it's for the autonomy and flexibility. So we could have basically a word of options in a contract. And creativity is something inherent to attorneys. Would you recommend using a lot of creativity in a contract when you're drafting the dispute resolution clause? Or would you suggest to go to the safety of templates of institutions?
I'm lecturing...
Both to the newcomer and to the experienced, I mean.
I'm lecturing since 30 years, and since the beginning, my advice has been, unless you're an absolute expert and your case requires that you deviate from the model rules, stick with the model rules. So these model clauses have been drafted by experts, and it's so easy to use them. You just open the internet, you say, I want the CAMS-CCDC as arbitration institution. You go to their website, you copy their model clause, and you are on the safe side. And it works for 98% of the cases. It works very well. I collect for the German cases on arbitration for the German government to give them to Amtszetral, to their database. And I would say 50% of the cases, arbitration cases, which end up in the courts later on because someone wants to enforce the award or someone wants to set it aside, 50% have a pathological arbitration clause. And I'm always astonished that in the age of the internet, you still find so many clauses which are defective. When it's so easy to take the clauses experts have prepared for the majority, large majority of the cases. It's very rare that you have to amend the clause.
That's perfect. And we always have the arbitrators to amend whatever has been left out of the arbitration clause. Stefan, thank you very much. And people from ESA, Escola Superior de Advocacia, thank you very much for having us here today.
Thank you very much. It was a pleasure. Obrigado for listening to us.